we had framed two issues on 28 January 2025. Thereafter, we have recast the two issues. First issue was whether the state can insist that a teacher seeking appointment in a minority educational institution must qualify the right. If so, whether providing such a qualification would affect any of the rights of the minority institutions guaranteed under the Constitution. The other question was whether teachers appointed much prior to issuance of notification of the NCT dated 29 July 2011, read with the newly inserted proviso, that is the second proviso in section 23(2), and having years of teaching experience are required to qualify in the TET for being considered eligible for promotion. Now, while considering these two questions in course of hearing, Pramati was cited before us. One group said Pramati does not require reconsideration. Other group said Pramati requires reconsideration. So we were also required to look into that point too. Now, we have on the section analysis and reasons divided our judgment into various parts, and ultimately what we have held is this. In view of the foregoing discussions, we respectfully express our doubt as to whether Pramati, insofar as it exempts the application of the RTE Act to minority schools, whether aided or unaided, falling under Clause 1, has been correctly decided. We say that we could have followed the 7-judge bench decision in Aligarh Muslim University and referred the issue directly to a 7-judge bench. But we have restrained ourselves from doing that. Instead, we have followed an old decision of 1965, Lala Bhagwan versus Ramchand, where Justice Gajendra Gatkar, speaking for the bench, said that in such situations, it is better that the bench of lesser strength refers the issues to the Honorable the Chief Justice to take a call. Accordingly, we have referred 4 questions to the Honorable the Chief Justice. 1, whether Pramati requires reconsideration. 2, whether RT Act infringes the rights of minorities. And assuming that Section 12(1)(c) of the RTE Act suffers from the vice of encroaching upon minority rights protected by Article 30, whether 12(1)(c) should have been read down to include children of the particular minority community who also belong to weaker section and disadvantaged group, to save 12(1)(c) from being declared ultra-vires. The third question is on the effect of non-consideration of Article 29(2) in Pramati. And finally, whether in the absence of any discussion in Pramati regarding unconstitutionality of the other provisions of the RTE Act, except 12(1)(c), the entirety of the enactment should have been declared ultra-vires, minority rights protected by Article 30. So therefore, we have directed that civil appeals 1364 to 1367, 1385 to 1386, and 6364 of 2025 to be placed before the Chief Justice. We have also said that there is another set of civil appeals 6365 to 6367, which should also be similarly placed for the reasons which we have indicated. Now, on the second aspect of order on applicability of the TET to in-service teachers, we have held in clear terms that those aspiring for appointment and those in-service teachers aspiring for appointment by promotion must, however, qualify the TET, or else they would have no right of consideration of their candidature. But at the same time, we have kept in view the ground realities and the practical challenges. And this is where we have issued certain directions under Article 142. There are in-service teachers who were recruited much prior to the advent of the RTE Act and who might have put in more than 2 or even 3 decades of service. They have been imparting education to their students to the best of their ability without any serious complaint. It is not that the students who have been imparted education by the non-TET qualified teachers have not shown in life. To dislodge such teachers from service on the ground that they have not qualified the TET would seem to be a bit harsh, although we are alive to the settled legal position that operation of a statute can never be seen as an evil. Bearing in mind their predicament, we invoke 142 and direct that those teachers who have less than 5 years service left as on date may continue in service till they attain the age of superannuation without qualifying the TET. However, we make it clear that if any such teacher having less than 5 years service left aspires for promotion, he will not be considered eligible without he having qualified the TET. Insofar as in-service teachers recruited prior to enactment of the RTE Act and having more than 5 years to retire on superannuation are concerned, they shall be under an obligation to qualify the TET within 2 years from date in order to continue in service. If any of such teachers fail to qualify the TET within the time that we have allowed, they shall have to quit service. They may be compulsorily retired and paid whatever terminal benefits they are entitled to. We add a rider that to qualify for the terminal benefits, such teachers must have put in the qualifying period of service in accordance with the rules. If any teacher has not put in the qualifying service and there is some deficiency, his case may be considered by the appropriate department in the government upon a representation being made by him. With the aforesaid modification of the impugned judgments and orders, there are several appeals which have been disposed of on the above terms. These are civil appeals 1389, 90, 91, 93, 95 to 99, 1401, 1403, 1404 to 1410 of 2025.